that anybody who owns a small business at this point should be aware of the Corporate Transparency Act to affect January 1st, 2024. Most small businesses will have to report the beneficial information to FinCEN, which is the report information about your beneficial owners, which are folks that own 25% or more of your business or have substantial control.
Alfred, thanks for sitting down with me. I appreciate it.
Thank you for having me.
As a business lawyer, please describe what you do and how you help small businesses.
Sure. What I do is work with businesses, anything contractual. I also do mergers and acquisitions, businesses buying or selling other businesses. I'll work in doing some financing transactions and real estate transactions because some of my small business clients need that as well. I also do entity formation, so forming a limited liability company, forming a corporation, those types of things as well.
Okay. Well, let's start from that. I think that's the most basic and initial first steps that a small business need to do before they can jump into operating. So describe the different kinds of formation structures that are available for small businesses, and depending on what the small business does, what should they choose?
There are many different forms that you can take. One I'll start with is it's not really a form of business, but the sole proprietorship. That's backing all the way up. Maybe it's a side hustle, what have you. You don't really have to form an entity to start a business. Me as a business lawyer, I would prefer that you do for the reasons I'll explain, but you don't have to. So you can just get out there and start doing it. The business structures that will allow you to have limited liability, though, to me are preferable for a variety of reasons, but one being limited liability. So if you have a limited liability company, it's in the name, a corporation, not a partnership, and I'll talk about that in a minute, but like a limited liability partnership, an LLP, a limited liability limited partnership, all of those different types of entities allow for limited liability, meaning if something happens, so you got a restaurant, somebody has a slip and fall, you get sued, the business assets are at risk, but your personal assets generally are not at risk. There are some exceptions to that, like if you are personally involved in creating a problem, then there may be the potential for you to have some personal liability there if you're negligent. But, not necessarily, the limited liability is there to shield your personal assets. You don't want people getting in your personal pocket. So that's the biggest reason, right? And so you want to protect against that. And for somebody who is just starting a business, a single owner limited liability company, doesn't cost that much to start up. I tell people, I prefer for people to do it with me, but I also tell them you can do it on LegalZoom. You can get out there, do that, and you can still get that in place so that you can have that separation between your personal assets and your business assets.
That makes sense. So it's more of on the protection side that an LLC would cover your personal liabilities more or assets versus on the business. So if you were to have an accident, like you said, for a restaurant, for any kind of business, you're protected on that end. At what point do you see an LLC making the jump to a corporation? And I guess we can break that down into S-Corp and C-Corp, right? There are two different kinds of corporation. Let me know if I'm jumping, the gun here. But.
No, that's good. That's good. Generally, I would counsel most people to get into like a limited liability company. You can change later on down the road to a corporation if you need to. If you are, one of the reasons though I would say that folks should get in a corporation from jump if they are seeking out venture capital. Because the funds that invest in like a venture capital fund, they only allow them to invest in corporations. So the venture capital funds only put money into a corporation. So most of them would only do it that way. So if you are looking for those kind of funds, then you probably want to get set up as a corporation. But the issue with the corporation is that double taxation. So the corporation as an entity gets taxed, but when you take the money out and pull it out, dividends for a corporation, it gets taxed again. So it's double taxation. So that's another thing. You always need a good accountant to help you make those decisions as well, run the numbers, because the corporate tax rate was reduced and things like that. So I think, it's a possibility that it may still work out for you, but that double taxation is a problem. Now, the S-Corp, like you talked about, is not necessarily a business entity. From like a state, Secretary of State, you go form this entity perspective, it's actually like a tax designation. So my limited liability company for my law firm right now is an S-Corp. You can have your corporation be an S-Corp. And what that helps do is to get around that double taxation problem, because like a limited liability company, a partnership, this taxed as a partnership, or this, is like a pass-through entity. A single member limited liability company is a disregarded entity. So everything just ends up on your personal tax return. So you don't end up with that double taxation. And the S-Corp is a way to avoid that double taxation as well. And it also has the additional benefit of you paying yourself under like payroll, and that self-employment tax over the amount that you pay that you are paying payroll for. You don't end up having to pay the self-employment tax, that 15.3% that owners have to pay over that amount that you pay payroll tax. So if you pay yourself, $60,000 or $70,000, whatever it is, whatever the proper number is, but you make $200,000, that extra $100,000 up until the phase out, you don't have to pay the self-employment tax on that. So that's the reason I have a good accountant to help you run those numbers and make those decisions.
So that's more of an accountant question, more than a business lawyer question. But I think you did break it down sufficiently for me to understand it, because now if I was to incorporate a business, I would preferably do an S-Corp instead of just doing an LLC, in case, most businesses, for example, unless they're doing it on the side, let's say a plumber, right? I think it just makes more sense for them to have an S-Corp LLC or a corporation to allow them to get those tax benefits.
Absolutely.
From the jump.
But so what I've read and what I've been told from good accountant is that the net profit kind of magic number is around $30,000 net profit. So if you made $500,000 but you only brought $20,000 home net profit, then it may not still work for you. But if you have $30,000 above, $30,000 above for net profit, that it could be advantageous to you from a tax perspective. So, but yeah, definitely run the number. I mean, I'm happy to talk with people about it, but you want to run the numbers with an accountant to make sure it's going to work out for you.
Yeah, so there are steps. So just getting started with an LLC initially first might be the best start, and then as necessary, making the proper adjustments with the accountant, going to an S-Corp.
Right.
Let's talk about partnerships, right? So partnerships, I would imagine mostly that applies for medical related businesses. For example, if I wanted to open I'm not a doctor certainly, but if I wanted to open a partnership with a doctor and I helped with the management side of the business, and he's a doctor, would that be a business entity that I would structure under a liability, a partnership?
So you could, right? And actually, that's something I meant to come back to. So thank you for coming back to that. A partnership definition is really just like two people going into business. I won't get this all the way technically correct, but it's two people going into business basically to make a profit. So if me and you start working together, then we could be looked at as a common law partnership, right? And so that's why you see in a lot of contracts, this contract does not create a partnership, does not create a joint venture. We are independent contractors and we're just working together on a particular project. And so the reason that's important is when you have a common law partnership, the law can look at you as I'm responsible for your acts and you're responsible for my acts, even though we never actually said that. Said that's what we want to happen. And also, you don't have the limited liability. So I'm responsible for your acts, you're responsible for my acts, and we're all responsible for 100% of the liability
On a
personally and everything.
Wow,
right? Your personal assets are at risk and everything. So that's why if you did want to do a partnership, you would either want to do a limited liability partnership get that set up with the state, or a limited liability, limited partnership, and get that set up with the state.
I mean, what would be the benefit of having a partnership structure then? Like, in what case scenarios do you see that being beneficial?
It's not beneficial.
Right.
And it's, I mean, you can have a general partnership and structure it that way, but you can basically have the same document and it's a limited liability partnership, and make sure you get the documents that you need to file with the Secretary of State and take advantage of the limited liability.
Okay. All right. So I guess we touched on the four things: sole prop, LLC, corporation, and also partnerships. Are there any other structures that business owners need to be aware of, depending on their industry, that they should consider before getting started?
I think those are the main ones: limited liability company, limited liability partnerships, corporation, the S-Corp as a tax designation. Of course, a lot of people are looking at nonprofits and things as well. Not obviously, you can't own anything in a nonprofit. The nonprofit owns it, and it doesn't. It doesn't. The person who founded it doesn't own it, and they aren't. You can be fairly compensated and things like that. But you don't get to take the extra and the excess. That stays with the nonprofit. So, I mean, people for various reasons want to do nonprofits as well, to have that, educational, charitable benefit to the community. And that's another thing that you can set up, but it's not really like a, business putting the money in my pocket, of course. So.
Well, who owns the nonprofit in that?
Who owns it?
The board members? There has to be a chair on a nonprofit.
Yeah,
right?
but the nonprofit owns the asset. There isn't somebody behind it that can benefit from it from the perspective of, if we sell, so let's say nonprofit has $1 million in assets, nonprofit has to either give that to another nonprofit, the cash to another nonprofit, or get the assets to another nonprofit. The members of that don't get to take that and put it in their bank account.
Okay.
So it's really a function of, it's governed by the board. You'll have your structures with officers and things like that. But it's for the benefit of the community.
The community. So it's normally a charitable work.
Yeah.
Understood.
So there really is no owner.
Okay. I've seen cases where people that have operated nonprofits for a very extended period of time and saw the benefits of that nonprofit turning into a profitable business, and they've made that jump and change. Besides the ethical, moral question, is that possible? Is that legal to do so?
It's legal as long as you pay fair value for the assets. So if I build it up in a nonprofit and it's $100,000 in assets, and I pay for those assets, the business takes out a loan and buys the assets from the nonprofit. The nonprofit distributes the $100,000 out to another nonprofit, or distributes it out to another nonprofit, and I can go on about my business. But you have to, the money, the cash that's built up in that business has to go for charitable purposes.
Oh, wow.
Doesn't get to go in your pocket.
So it's not as simple as I'm changing the nonprofit to a corporation through an operating agreement, and therefore now I am a for-profit business, even though initially I started as a nonprofit. So it has to go through, the assets need to be divided in a fair manner.
There actually has to be a transaction. I mean, if there aren't any assets, then it's just you start a different name, that kind of thing. But if there's assets, then there has to be a transaction. They're supposed to be.
Yes.
I don't know if that always happens. But.
You're right. With most nonprofits, I understand. Okay, give us a little insight on what small businesses face if they're not established properly with the form of a structure that will protect them from any kind of liability.
I mean, the issue is they can, you could get to, number one, somebody trying to sue you, a creditor, somebody that you were doing business with, and they, the business has went bankrupt, basically. You still owe them, but if you don't have that limited liability set up, then they can come after your personal assets. If you're just out there as a sole proprietor, because there really is no difference, right? The business is you when you're a sole proprietor. So there's that part. And then the other part is kind of having it structured from the perspective of, if you have multiple people that are in business together. I've seen it where people have an agreement, they try to update the agreement themselves, or which is fine if you do it all. But if you kind of leave it hanging out there and it's like, okay, the agreement says we're 40-20-20, 40-40-20, but we're really a third. Well, that's not what the agreement says. So then you have to go to extraneous evidence. You got to try to find all this evidence and figure out those kind of things. I've heard of, this wasn't my client, but I was talking to somebody else who was doing some work for some folks, and one person had all the financial information, and they didn't have an operating agreement that says, and that's one of the things, the operating agreement is what says who owns the business. It's not something that you file with the state. It's, so that's the agreement by which you operate the company, right, for a limited liability company. And they didn't have one, and the person had all the financial information. They needed it, and they were like, well, no, I'm not a 10% owner, I'm a 25% owner. And it doesn't say anywhere definitively where that discussion happened. That's a problem. And they're holding the financial information hostage because they want an uptick in their interest. So those kind of things, when you are working with other people, I say, you could still do legalism and stuff, but I don't really recommend it for that, because with those transactions, you need to be thinking through things like the management, right? So can somebody go out and take a $50,000 loan without consulting the other partners? Can somebody sell the business without consulting the partners? And members in a limited liability company, partners in a limited liability partnership. So I'll just use partners interchangeably for purposes of this. But can you transfer that interest? Can you put a lien on the assets? All these different type of things that you have to think through. And whether the levels, is it $25,000 loan? Is it 50? Is it 100,000? Is it $5,000 loan? You want to think through all those things and what are the authority of the different folks to be able to manage the business. So there's a whole litany of things to look through there. And then there are also, you need to think about the transferability of the interest. Is it transferable? Is it not transferable? Can you transfer it to a family member? Can you transfer it to a trust? Can you, if you are able to transfer it, is it subject to a right of first refusal? Meaning the company gets to get the first crack at that interest to buy it back. And if the company doesn't want to buy it, the other members can buy it, to be able to keep it, so you know who you're working with, right? As opposed to you just being able to go out and sell it. And maybe you want it to be freely transferable. But those are the kind of things you need to think through. If the majority owner, 51%, decides to sell the business, can he drag me along with them? Or does he have to get my consent and I can hold it up? All those kind of different things you need to think about when you're in business with somebody else. And that would be a part of the operating agreement, or it would be a part of like the certificate of incorporation and bylaws for a corporation. It'd be a part of the partnership agreement for a general partnership or a limited liability partnership. So all of those kind of things you want to think through, think about them, and make sure you get those memorialized.
Yeah, well, that's a very important piece, because I've seen small businesses just go online on Google and find a template of an operating agreement and just basically put the business's name, whatever percentage, whatever dash is available there, they put the name or the percentage or the date and present it for even lending transactions, which is surprising to me. And I always advise that they consult with a small business, with a lawyer before they can do that. So I think you're just emphasizing on how important operating agreements are, especially when you're working with a different party involved. Have you seen any pitfalls that a shady operating agreement that kind of led into a fallout of a business transaction, ending in litigation?
So I saw, one of the ones I was talking about where it's supposed to be like, it's 40-40-20 on paper, and it's supposed to be a third. Yeah. I think that one was heading there. I didn't see it go to litigation, but I think that one was heading there. And I think anytime you have something where you have these kind of handshake agreements, especially when it comes to ownership, I think those are the kind of things that can happen. So you have to be cautious about it.
I understand. So how can we, a small business owner, manage the cost of having a legal support into consideration as they are, going about a new venture on a business? How important is it? It's very important. I'm sure it is. But cost-wise, depending on the industry, depending on the venture, the size of the venture, do you put a percentage to how much a business should consider taking legal support and getting a business going?
Yeah. So, like I said, a person who's you're doing your thing, sole proprietorship. You can go out to LegalZoom, get it done. I mean, you're the only one operating the business. There aren't all those other considerations when somebody's working with you. It doesn't cost that much. I don't even I don't charge that much for it. So I try to make it, generally affordable. And I'll be transparent with the pricing, right? So I've been charging like $350 to set up a single member LLC. I may bump that up because it takes a little bit of time, but it's filing the articles of organization. It is doing the operating agreement and also doing the EIN for folks that you need to get the bank account, as you know.
Right.
And so that usually I only charge an extra $50 for that. So it's $350. It includes that. It also includes the $50 that you have to pay to the Secretary of State to set up the limited liability company. So I don't think that's that much money, and I was actually thinking about this because I thought you would ask me that question. I don't do them as much now, but I used to do tickets, right? And same price. $350, shell it out, no problem, because you don't want points on your license, right? You don't want your insurance rates to go up, but there would be more hesitation a lot of times with paying the $350 to set up the limited liability for my business, which will keep people out of my personal pockets on a much grander scale, right? Same cost. So that part is affordable to me.
Let's jump subjects. Merger and acquisition is something that you do as a business lawyer. So describe a typical merger acquisition transaction that you oversee before it goes into effect.
Yeah, so I think a lot of it will happen like before I'm involved, because people just they're thinking about it. They want to they're searching around. They want to find a business that is just a financial buy for them. They have the money. They want to get into a certain business type, or it's a strategic buy. They're already in that space and they want to kind of bolt on a business, and they'll a lot of times start looking for folks, talking. They might use a business broker. They may find it themselves, talking to folks, doing those kind of things. But the point usually where I get involved is usually the place I should be involved, and the place I get involved is usually a little bit different. But the point usually where I get involved is usually the place I should be involved, and the place I get involved is usually a little bit different. Generally, when somebody is disclosing the financials, so that's the first thing that the purchaser will want, then there should be like a confidentiality agreement from the sales side. That won't always be there. Sometimes it will be. But from my perspective, as I'm playing attorney for the buyer here, I want to be able to look at that confidentiality agreement to make sure there are, aren't certain things in there, and potentially limit the scope as far as like the amount of time that's involved with it, non-competes, non-solicitations, all those kind of things. And there are things that you can do to limit the effect of those. After that, generally what we'll do after the owners looked at the financials and kind of has a number in their mind for what this company might be worth, then what we'll do after that is send an initial due diligence request list. So they can be tailored to the specific transaction, but that'll ask for, contracts. Let me see the insurance on the business. Let me see the financial stuff that you might have already seen could potentially be on the list. Other things you might need to see. Let me see things about the employees. All those different types of things that you need to know to be able to do your due diligence on the business. So then when you get those documents, you go into sort of a due diligence period. And let me step back. Usually with the initial due diligence request around the same time or probably before, a letter of intent, which will kind of set forth how we're going to approach this transaction. Like, this is how much we think the business is worth. It's subject to due diligence. It'll say, that part. It'll say things like, you aren't going to go out and shop this business and sell out from under me while I'm spending money for lawyers and accountants to look at and do due diligence on this business. So it'll kind of set some parameters about the transaction. Then we'll do the initial due diligence checklist, get the information back, get the accountants involved, whoever is doing the valuation, looking at the financials for you. Lawyers will look at the contracts and things like that. If there's employees involved, you may have somebody that's in your business or a consultant to look at those types of things. So if there's environmental issues, you may need an environmental expert. You may need a phase one for somebody to go look at that piece of property and say, is it okay for me to buy it? So all these things happen in the due diligence process, and kind of simultaneously, you are also after you get to the letter of intent. Once you get into the due diligence, you're able to see kind of what different things that you may need to protect yourself against, and you draft a asset purchase agreement or stock purchase agreement or membership purchase agreement, depending on what kind of entity is on the other side. And you draft that, negotiate that back and forth, and then you close the transaction. So that's kind of in a nutshell what the process is. But for folks that are going to sell, I think it's certainly an exercise in making sure you have all your ducks in a row. So like, it's a good reason to have kind of good housekeeping for contracts and those kind of things. You don't want to have a whole bunch of contracts in your files that are unsigned or signed by only one party. Then you go to present this to a buyer and it's like, okay, where's the other signature? Right. Or you got a file that's it's got 10 amendments, you only got 5 in there. And so it's good to practice having, good financials, good paperwork, all those kind of things, so that you're able to present that in a good fashion when somebody's trying to purchase you.
Okay. Yeah. So I would imagine merger and acquisition deals normally happen for established businesses and also people that are established to be able to buy them. So do you see the benefit of, incorporating a business from the ground up versus buying an established business? Granted that those are two separate transactions overall, but how can one separate, for example, if I wanted to be in a tech space or if used car space or whatever the case may be, do you see the benefit of merger and acquisition transactions happening even more than just establishing business?
The benefit from whose perspective?
From the buyer's perspective, from a new business owner or a buyer's perspective.
Yeah, I mean, I guess it kind of depends on how you feel about entrepreneurship, right? Yeah. Like if you are okay with the grind and the late nights because you want to be your own boss. You want to build something, right? It's not just about the money. You want to build something. You want to help people. Then I think that part is okay, right? And you also may not have as much debt on that particular business as well if you go about it that way and build it up. If you got the cash though, right, you get to skip all that. Right. And obviously you need to have some expertise or keep the owner on or get familiar with it so that you can operate the business in a fashion to be able to continue to be profitable. Because if it wasn't profitable, you probably wouldn't be buying it in the first place. Right. But to continue to be profitable, I think if you got the cash and you can skip all that, it really kind of depends on if you got the cash, really.
I understand. I've seen a recent merger and acquisition deal between Sigma and Adobe. I don't know if you're familiar with that transaction. It didn't happen because of regulators. How often does that come into play as you're helping small business owners or any kind of size business owners, make that leap and purchase a transaction? Is that something that you consider the regulation piece of it? Does that even come into play in most of the transactions?
Not for transactions of the size that I would be doing. Yeah. I'm not gonna try to quote the antitrust regulations right now. Right, but you're talking about in the tens of millions of dollars, in the upper tens of millions of dollars before those regulations come into play. I see. And so other small businesses won't have to worry about that. Obviously, if there's like licensing and permitting, those are things you find out about in due diligence, and you may need to make sure that you're able to get a particular license and permit. And one of those, now that kind of thing does come into play with regulation, because a lot of times when you're the buyer, you're trying to buy the assets of the business because you don't want to take on all the liabilities, right? If you buy the entire entity, like a stock purchase agreement or a membership purchase agreement, and you buy that entire entity, people can come after you for everything that happened before, right? Mm-hmm. You will have the seller indemnify you take on that risk for things that happened before, but that's only as good as as you getting them to take care of that or setting aside an escrow so that you have money to take care of those kind of things. But with respect to the regulation side of it, you may have to buy the stock, right? Because you don't want to have to go through the process. It may be so arduous and so such a rigorous process to be able to get that particular permit that you may say, we just need to buy the entire thing. Uh-huh. So that could be one of the considerations with a small business if it's a highly regulated, like, medical care or some, those types of entities that, have that particular license that you need to operate. You may end up buying the stock of it, and it'd be a consideration from that perspective of doing stock versus assets.
Assets, and I understand. Yeah. Speaking of assets, one of the things that comes to mind would be properties, right? And then, so in any kind of, I've seen one of the things that you help with small businesses get their ducks in a row is a promissory note, right? So lending transactions between companies or even individuals. What needs to be taken into consideration from your experience that small businesses need to think about and the importance of having that promissory note agreement in place for transacting money, per se? Yeah,
absolutely. One, I think you have more time to enforce those notes if it's written down than you do if it's oral. Right. Don't quote me on that. I think that's the case. I would have to look it up. Okay. Also, just from the perspective of instead of going with he said, she said about money that somebody owes you, you want to know the exact amount that was lent, right? You want to know the interest rate. You want to know the terms if they default, all those kind of things. And you want to have that in a promissory note for sure. And then there's other things to consider as well, depending on the amount of money, right? Is it just a promissory note that's not backed by anything? Or is it a promissory note that has a guarantee embedded in it, meaning I want you, so let's say it's a business on the other side. Do you want a personal guarantee with it as well? And, you as a banker,
yeah,
you
would need it. You would need it depending on the transaction. Unless it's a nonprofit, for example, let's say it's a separate transaction, but most often than not, you would want that personal guarantee.
Right.
In any kind of lending transaction.
And if it's a new entity that's been in business for 3 months or just set up for this transaction, you want a personal guarantee from the parent. So those are things to think about, right? And so even in that space, in a merger and acquisition space, the seller can give back a note for part of the transaction, right? But do you want some kind of guarantee on that seller note? All those kind of things. Do you want security on it, right? Like put up the house or put up this or put up that, right, to secure that particular note. So all those things are considerations and things to think about and why it may be good if it's a substantial amount of money to have an attorney look at it.
Yeah, certainly. I think money transaction does happen, and as a lender, personally, I know that every single thing needs to be on that promissory note and also the business loan agreement before we can lend in. And assets as a collateral are a very important piece, because if you're not going to guarantee the payment for any reason, then I'd like to have that backup as a collateral to come in and collect and make sure that I'm paid, right? Do you help small businesses do transactions with banks as well? If they were to take in debt, for example, do you go through those steps with them, and how does that look like?
Generally not for a smaller business, because as you know, the form is going to be what the form is. A lot of times there won't be any negotiation on it, but I still advise them to look at it. But I've had bigger businesses, larger businesses. I do have some clients that are much larger, have loans in the millions, tens of millions of dollars, and I have looked at those transactions from their perspective as the person who's taken out the loan.
I see. I understand. Mm-hmm. What advice would you give small business owners as they're considering to have a lawyer in their team, right? Mm-hmm. At any capacity, what are the things that they need to take into consideration, or they need to see? It could be experience-wise, whatever the case may be. What do they need to see before they can actually say that I want to hire this small business lawyer and to back me up?
Yeah, I guess one thing, I guess to back up a little bit is part of the thing we said at first. You know what? And so what I would say is, you know, one, there are lawyers that are generalists that do a lot of different things, but there's the transactional side, right? And there's the litigation side. You get sued, you're going to need a litigator. If you want to sue somebody, you're going to need a litigator. I don't do that. I give people referrals. From a transactional perspective, those are the things I do. You know, there's all kinds of lawyers for all kinds of things. One of the other things, you know, people want to pass their business down or their wealth and assets down. Another thing that I do that I didn't mention is estate planning work as well. And so different lawyers for different things, right? I would, you know, some lawyers you won't be able to talk to them without a consultation fee. We do value our time, is how we make our money. But I would do some research, right? Look up, you know, look at the website, look up reviews if there are any. If you have the opportunity to talk to them, try to gauge, you know, what their experience is in the type of transaction and the thing that you're asking for them to do, right? And a lot of people get folks from a referral, right. And that's one of the best ways because you can talk to that person about how their experience with with that lawyer, how did they treat them, how was their customer service, how was their responsiveness, that type of thing. So I would say just kind of do your due diligence, try to research as much as you can, talk to the person that referred them, to try to figure out, you know, and do your research and try to make sure you're getting the right kind of lawyer for your particular problem.
Right.
Because, you know, it depends. Some people will take on all kinds of stuff. Some people won't. So right. You need to make sure you're getting the right kind of lawyer.
Due diligence. It goes back to doing the due diligence. All right, so just to finalize things, what are the 1, 2, 3 steps that a small business need? Excuse me. What are the 1, 2, 3 steps that a small business needs to have in place before they can operate from a perspective of a small business, lawyer? Mm-hmm. What are the things? The first 1, 2, 3 things that you would say?
I would say that what you need to do is make sure that you are getting into an entity to set yourself up with limited liability. And then once you are set up with that entity, part of that process is to actually do an agreement. So you file articles of organization or you file articles of incorporation for a corporation, articles of organization for a limited liability company to set yourself up with the state recognizes this entity, right? Then you do the operating agreement or you do the bylaws that says this is actually how I plan to operate or run this particular entity. And you get that taken care of so that you have that, especially like we talked about, when you have multiple members and more than one person. And then the other thing I would say, and you know, you can or cannot spend as much money as you want on these things. Like I said, LegalZoom's an option. Yeah, getting a form and doing it yourself, you know, is an option if you don't have the money to do it, especially with a single member one. But also get a good accountant, right? That would be my next step because they're gonna be able to tell you about different deductions and things that might save you money. They can have that S-Corp conversation with you. It might save you money. They can help you keep your books in order, or at least point you in the right direction, keeping your books in order. So when somebody's looking to buy your business or when you're trying to get a loan, those types of things, that everything's in order. I would say those are my first steps.
Is there anything else that you'd like to put out there?
Sure. The one thing that I would do that anybody who owns a small business at this point should be aware of the Corporate Transparency Act. It's an act that went into effect in 2021. Got passed in 2021, but just went into effect January 1st, 2024. Most small businesses will have to report the beneficial information to FinCEN, which is the Financial Crimes Enforcement Network, which is a division of the Department of the Treasury. So you will have to report information about your beneficial owners, which are folks that own 25% or more of your business or have substantial control, a senior officer. You will have to report various information about that business. And so there are penalties as far as fines and even jail time for kind of intentional stuff. that you need to be aware of. So you want to make sure you get those forms in. For businesses that were established before January 1st, 2024, you have until December 31st, 2024 to get that form in. So you have a whole year, basically. If you establish the business between now and December 31st, 2024, you'll have 90 days to get it in once you establish that business. Starting January 1, 2025, you have 30 days to get that form in. So I just wanted to put that information out there as well.
Wow. Well, that's a very important piece. That's very new, even news to me as well. Where is that information provided?
Just Google FinCEN, FINCEN. It'll pop right up, and there's a wealth of information on the government's website. There are small business. There's like a 56-page small business compliance form. They have the regs out there. They have frequently asked questions. There's a wealth of information that you can take a look at.
Do you think it's best to hire a business lawyer to be able to go through that transaction with that regulator?
I think it depends on what you're comfortable with. It's just reporting your own information. So if you're comfortable, you can do the form online. If you're comfortable with it, a business owner could absolutely do it. But if you want to hire a lawyer to do that, you can do it that way as well.
Are these for active businesses, active LLCs and corporations? Let's say a business that has been established 10 years ago, the member was not really operating it, decided to completely forget about it, and it has dissolved.
Yeah.
So does that apply to dissolved entities as well, or is it just active entities?
So there's an exception for inactive entities, but you have to have been in existence for a certain amount of time. You have to have not received or sent out like more than $1,000, I think, within the past 12 months. And there's other different aspects to what that exception is for an inactive entity. So you would have to look at that particular exception, and all that's in that small business compliance form. It has little check boxes and everything. You can look at it, see if I qualify for that particular exception. And for dissolved entities, I believe that it also applies even to dissolved entities, unless you actually dissolved it with the Secretary of State's office. So you actually went to the affirmative step to actually cancel the entity with the appropriate Secretary of State's office. If you didn't do that and you kind of just let it run its course and it's still out there, and it could fall under that inactive business entity exception, but you have to meet the requirements. Great question.
I see, I understand. Well, this is very new. Do you think there's more, is there enough awareness to actually have small businesses take action? Because as you were saying, fines are associated with it, and also could be jail time if there's intentional bad actors with a certain LLC. So do you think there's enough awareness?
I've been seeing stuff kind of like in lawyer circles. I don't think there's enough awareness. And from a broader business perspective, business community perspective, I did see an article about it on Yahoo where the Secretary of Treasury was saying that 100,000 businesses have already signed up for it. So I think it's out there. I think lawyers are helping to spread the word, probably some accountants helping to spread the word as well. And that's why I wanted to make sure I brought it up on your show.
Oh, absolutely. Great. Disclaimers, anything that you'd like to put out before we can wrap this up?
Sure. Just want to say that everything that I said was for educational purposes. Please either look it up yourself or go to an attorney to have them look up the particulars as well, only for educational purposes and not legal advice.
Oh, same here as well. The reason why I decided to do this is because I think small businesses could benefit from expert like yours, right? I mean, on the law, and certainly we'll do it on the accountant side and any other experts that are willing to come to the show as well. Thanks, Alfred. I appreciate it.
Thank you for having me. I appreciate it as well.